Students often ask me, how do I deal with multiple choice questions in law school? And I'm here to help you do that. I created a video for you today to take you through a multiple choice question. And my first thought is that it's really not that different than writing an IRAC style law school essay. I have some videos on IRAC, but briefly it means identifying the issue, naming the rule that pertains to that issue, analyzing which facts would weigh in favor of one party or the other under the rules you mentioned, and then concluding whose weight is stronger, which party should prevail. Really, we're going to do something similar when we go through this multiple choice question, but it's actually quite a bit easier than that because we have a lot of nice direction around what issues we want to deal with. So let's take a look at a multiple choice question. I have one here for you on the screen. This is a bar style question in contract law. And let's take a look at it. And the first thing I want you to look at actually is skip all this. This is the fact pattern. This is the prompt. This is the question. And we want to actually begin by making sure we understand what is this question about. We don't want to accidentally have our minds in a mindset thinking about constitutional law when this is a contract claim. If the man brings a suit against the gardener for breach of contract, who is likely to prevail? This is great. So we know that we're limiting ourselves to within the realm of contract law. On the bar exam, you have a number of different subjects tested right next to each other with multiple choice. So you want to identify your issue area. And in fact, if we just continue down and take a quick glance at our answer choices, we'll find that there are only a couple of areas within contract law we have to consider. First, this question clearly pertains to the doctrine of promissory estoppel, which relates to the absence of consideration. So there could be an issue involving consideration, which is one of the three elements of what a contract at law requires. Of course, there are exceptions at equity in quasi-contract. Choice B talks about acceptance. Contracts also require acceptance. That's another one of the number two out of the three big things. Offer, acceptance, and consideration are elements that all contracts require. And choice C also pertains to acceptance. However, they're distinguishable because the answer in the first case is that the contract was formed and therefore the man prevails. And the answer choice in C is that the contract was not formed because he never accepted. So acceptance could be pretty important. And the gardener because he offered to cure the defective performance. So we have an issue of cure and defective performance, which has to do with formation of a contract and then later whether or not there was time to cure after a breach. So you have a couple different issues, but notably what isn't here, we don't have an answer choice that has anything to do with offers. We don't have an answer choice that has anything to do with statute of frauds. We don't have an answer choice that has anything to do with infancy or misrepresentation or mistake or undue influence or duress. I could go on about all the things it's not. That's great news because those are things you don't have to think about when dealing with this fact pattern. The answer choice has made it clear what we should be focusing on. And so let's make even a little bit of list for ourselves. So this could pertain to a couple of different issues. Let me make sure this gets into your screen. So we want to be looking at issues including consideration or promissory estoppel, acceptance by performance, and maybe breach and cure. And that's it. And so what do we know about these things right off the bat? Well, we know that all contracts require consideration, and consideration is a bargain for exchange. However, in equity, we might enforce some promises that are not supported by consideration under the doctrine of promissory estoppel, or sometimes called detrimental reliance. We know that contracts can generally be accepted either by promising or by performing, and we have some special rules around unilateral contracts that can only be accepted by performing. And we know that material breach is governed by Section 241 of the restatement, and there is a cure period until we move into total breach under 242. So let's take a look at our facts now with that mindset, and now we have a much narrower way of looking at these facts. Hopefully that will help us get the answer. On Monday, a man told a gardener, I'm having a party on Sunday. Okay, dates are usually important. Let's highlight that. And I want my house to look good. If you promise, okay, promise, I like highlighting that, to mow my lawn, that's what the promise is for. Maybe use a different color. By Saturday, okay, so we have some more dates in here, I will pay you $50. Okay, stop here. Can we rule out an answer choice already? Yes, we can. Which one of these issues comes up? Consideration comes up. Consideration means a bargain for exchange, that a promise and the consideration are both part of the bargain, that both parties are induced into a contract by what they will both give and what they will both get. Well, in this particular example, we have a very clear offer, and we know that offer is not an issue, so we have an offer. The offer is to mow the lawn in exchange for $50. That is a very clear example of consideration. The consideration is the mowing the lawn. The promise is paying the $50. Okay, so we don't have a consideration issue. So right off the bat, I think that we can eliminate answer choice A, because in fact we don't need the doctrine of promissory estoppel to make this enforceable. Rather, we have consideration here, and so we don't need to worry about that. Hey, look, we're only in the first sentence, and we've managed to eliminate an answer choice, so we're well on our way to getting the right choice. We've just increased our percentages of getting this right. Even if we were to guess, we've eliminated one wrong choice. All right, think about it, check your schedule, and let me know. Well, this is important because it means that the power of acceptance survives the duration of this conversation. And check your schedule and let me know sounds like it's inviting a promissory acceptance, meaning it seems like it's inviting the gardener to accept by letting him know, by promising to pay. But that's not what happens. Instead, on Friday, another date, let's take a look at that, the gardener arrived at the man's house just as the man was leaving for work and began to mow the man's lawn. Well, this should, if you've spent time with contracts, trigger acceptance by performance. This is the performance of the exchange that was contemplated by the bargain. So is this, in fact, a valid acceptance by performance? Let's take a quick pause here and look at the rule regarding acceptance by performance, and I will bring you over here. Okay, very good. So here's section 50 of the Restatement Second of Contracts, and let's take a quick look. Obviously, this is going to deal with acceptance by performance, which is the issue here. Sub-rule 1, acceptance of an offer is a manifestation of assent to the terms, made in a manner invited or required by the offer. Well, this offer seemed to suggest that we could accept by a promise, but it didn't exclude acceptance by performance. So we can go on to number 2. Acceptance by performance requires that at least part of what the offer requests be performed or tendered, and includes acceptance by performance which operates as a return promise to complete performance. Okay, that means that in order for this to be a valid acceptance by performance, the offeree must have performed part of what was requested. Did he begin performance? Yeah, he began to mow the lawn. He began to mow the lawn. And so when he began to mow the lawn, that sure looks like acceptance by performance under section 50 sub 2. So we look like we have an acceptance here. And so answer choice C is looking suspicious, even if we just remembered the rule in section 50. Before we rule out that answer choice, though, let's take a quick look at just one more rule, which again, you probably could have gotten this answer right even if you didn't remember rule restatement second section 53, but this helps a little bit. So if you know more rules, you'll get more answers correct quicker. So this pertains to acceptance by performance. An offer can be accepted by the rendering of a performance only if the offer invites such an acceptance. Was an invitation accepted here? Well, it wasn't specifically mentioned. He didn't say you could accept this by beginning to mow my lawn tomorrow. But if you had read the comments and you had followed along in class, you would have seen that in fact the default is that acceptance by performance is usually permissible so long as it's reasonable under the circumstances. Where either acceptance by performance or acceptance by promise is reasonable, the offeree may choose between them. And that seems to be the case here. There was nothing in the fact pattern that expressly excluded the possibility of acceptance by performance. So going back to our fact pattern, I think we can now rule out answer choice C. I think we can now rule out answer choice C because in fact the contract was accepted by performance. This is great. We're only like halfway through the fact pattern, and I think we've done a nice job excluding things basically that they just didn't meet the elements. There aren't strong arguments on the other side. Let's move on. When the man said nothing to the gardener but drove off as he saw the gardener unloading his lawnmower, Okay, so now we have additional facts that support our ruling out of C because the offeror was notified of the acceptance by performance, eliminating any doubt that that acceptance was valid. However, when the man arrived from work that evening, he noticed only half the lawn had been mowed. And he found a note from the gardener slipped into his mailbox that said, effectively, I'm not going to finish the job on time. Well, at this stage, we only have two answer choices to deal with, answer choice B and answer choice D. Answer choice B says that the part performance implied an acceptance. We've already talked about that being true. The question is D a better answer? D has to beat that answer. The gardener offered to cure the defective performance by finishing the job on Monday. Well, I mean, even without going back to the rules of contract law, and we could look at Section 241 and 242 on material breach versus substantial performance, and on total breach versus partial breach, and on repudiation. But we could also just use some common sense here. This was a contract with time of the essence. Let's go back to those yellow highlights. I need the lawn mowed by Saturday for a party on Sunday. Is the value going to be the lawn mowed on Monday? No. In fact, this person is made worse off because they have a half-mowed lawn, which is probably even uglier than a fully unmowed lawn. So there isn't a cure period because, in fact, the time for performance has lapsed. We are outside of the bounds of when the performance is desirable. This is not going to give us the benefit of the bargain, and so we can rule out answer choice D, leaving us with the correct answer, answer choice B, which, again, we should review and make sure that it works and makes sense. But here we don't have any problems with it. We know that we can accept a promise by performance or by promising. There's nothing in this offer which excluded inherently acceptance by performance. Again, we had to identify those issues, but they were sort of handed to us in the fact pattern. And as we worked through them, we found that acceptance was almost certainly valid. And that acceptance constituted a promise to render complete performance, just as if he had said during that conversation, yes, I will mow your lawn. By bringing the lawn equipment out there, he effectively said that. He effectively at least implied that. So I hope that was helpful. In another video, I'll go through one more example on a slightly trickier fact pattern, but here we had a very clearly right answer, a number of wrong answers. By the process of elimination, we were able to rule out the wrong answers and move on. So I hope that helps you answer multiple choice questions for contracts on the bar.